Hey everybody. Well, it's snowing like crazy out here, and if any of you are down in Florida, I'm very jealous. But while I'm stuck here in the middle of our second blizzard in the state of Minnesota this winter, I'm going to go over briefly with chapter 15 and 16 for this week's lecture YouTube video session. Okay, chapter 15, I'll briefly cover a little bit on search and seizure. Much of this will be review from most likely your Intro to Criminal Justice courses. Okay, the chapter outline. Fourth Amendment, we'll talk a little bit about the warrant requirements, exceptions to the warrant requirement, and the exclusionary rule. So the Fourth Amendment, if you're going to remember any amendment in the Bill of Rights with regards to criminal law and procedure, please make it be the Fourth Amendment. This amendment gives people the right to be secure in their persons, houses, papers, and effects, and it really protects them from unreasonable searches and seizures without a warrant issued based on probable cause. There's a lot of important words there, okay? Search. When the government agents look for evidence in a manner that intrudes or invades a person's legally protected zone of privacy. Now, government agent. That does not mean that someone who is not a government agent, all right, let me just say this. You're walking through Target and you decide that you want to steal something. You put it in your purse, and the private security officer grabs you and he starts searching your purse. He does not need to have a warrant to search your purse because, based on this information here, a government agent, that would be a law enforcement officer, somebody who's working for an enforcement agency. So just kind of wrap your head around it. Law enforcement has much more restrictions with regards to requirements for warrants, for searching, for taking a person into custody versus someone who is a private security officer, okay? Now, seizure, that takes place when government agents take possession or control of property or persons. A warrant is basically a writ or an order directed to a law enforcement officer issuing or authorizing, I should say, a search or a seizure. And probable cause. Um, it's basically a reasonable grounds for belief in certain alleged facts. Warrant requirements. Probable cause is needed for a warrant. This exists when a prudent and cautious police officer has trustworthy information leading them to believe that evidence of a crime might be obtained through a search. So what do we need to create a warrant? Well, we need a warrant application. This will be given to a judge for review. However, along with that warrant application that is generally generated by an investigator, a supporting affidavit also has to be um, created or generated, which has supporting facts. And to get a little bit more information, if you want to see what one looks like, you can look at page 442 in your text. In addition, specific description of places searched and persons seized has to also be included in your warrant application and supporting affidavit. The investigator who creates these documents is known as the affiant, all right? Now, for anticipatory search warrants, which are usually used for drug arrests, these types of warrants do not require probable cause. Probable cause does not have to exist until the warrant is executed and the search is completed and conducted. For example, if a DEA suspect or a DEA agent suspects narcotics are being sent to someone's house via U.S. mail, a warrant is issued prior to taking custody of the package, but probable cause is not needed for that warrant, and the probable cause is ultimately established once the package arrives. And I know that might seem like a little bit of a slippery slope. Hey, who's to say that, an agent isn't going to violate someone's Fourth Amendment rights? Um, but there has to be probable cause established once that criminal activity is completed. And again, I would strongly encourage you to read your text to get a little bit more in-depth information on this. Um, Executing the search warrant. Well, state and federal laws govern the specific times and manner with which a warrant is executed. For example, a warrant cannot exceed 10 days. Once a judge or a magistrate signs your warrant application, you have 10 days to execute that warrant. If it is not executed within those 10 days, that warrant is considered stale and no good. And most warrants must be executed during day hours unless there's specific circumstances that dictate otherwise. Now, the knock and announce rule. This is a provision under federal and most state laws that requires a law enforcement officer to knock and announce his or her presence and purpose prior to entering a person's home to serve a search or arrest warrant. The purpose of this is to reduce the potential for violence. I mean, think about it. You're sitting there watching TV and someone kicks your door in. You never know. Someone might have a big shotgun sitting right next to the couch. So it reduces the potential for violence against law enforcement, but it also protects the privacy of people who are inside the house. Now, problem is there's no specified time an officer must wait prior to entering with force. And a lot of times you'll see it on TV where you got the SWAT team standing outside the door saying, "Open up, it's the police." 2 seconds later, boom, they kick in the door. Um, but now, if no one does allow entry into a home, officers are fully allowed to break open any door or window of the house to execute that warrant. Now, there are some exceptions to this rule. For example, drug cases. No announcement is necessary if there's the possibility that evidence will be destroyed, which is, really common sense. Um, I want you to read over the exceptions to the warrant requirement, but I'll briefly skim through a couple here. Evidence in plain view. So you get dispatched to a medical, you get inside the house to assist the victim, and you look over on his dining room table and he's got 3 pounds of marijuana sitting there. You do not need a warrant to arrest him based on that information because the evidence of the criminal activity is right there in plain view, okay? Also, you don't need a warrant to seize it either. Emergency search. 911 sends you on a domestic assault call, and when you get to the house, no one answers the door. You do not need a warrant to make entry because it is considered an emergency search. You want to make sure everybody is okay. Same thing with a fire. You go to a fire call, excuse me, you don't need a warrant to make entry into the house to put that fire out. Preservation of evidence. For example, you respond to a traffic crash and you see that the person who caused the crash is a drunk driver. He's refusing to give you any type of a breath test. So you do not need a warrant to take blood from that person. And the reason being is that evidence can dissipate fairly quickly. Search incident to a lawful arrest. You know what? Basically, that's common. You handcuff somebody for a criminal activity, you search them right away. You don't need a warrant to do that. Hot pursuit. Someone's fleeing you and they run inside of a house. No warrant is needed to make entry into that house. You just go right on in. And then the automobile exception. Officers may stop vehicles without a warrant as long as they have probable cause for the traffic stop. There's a lot of other things, though. I mean, you need to have some. I'm not going to say as soon as you stop the car, you can start doing all kinds of searching. There's a lot of different criteria that needs to be met as well. And again, these are more um, in depth, described in depth in your chapter. Okay. What's the exclusionary rule? Again, review for you. It's the judicially created rule that prohibits the use of illegally obtained evidence in a criminal prosecution. The fruit of the poisonous tree doctrine. This holds that evidence derived from other evidence that is obtained through an illegal search or seizure is itself inadmissible. So you go into someone's house, the suspect has a computer, you believe it's got child pornography on it. You don't have a warrant to take the computer, but you take it anyway. Okay, you have just violated that suspect's Fourth Amendment right based on the fact that you did not get a warrant for that evidence. Now, you decide to take the photographs off of the hard drive, print those out, and a judge says, sorry, that computer was illegally obtained. It's tossed out as evidence. Well, I have these photographs, Your Honor. Sorry, that also was illegally obtained because you did not have a warrant to take the computer. Therefore, anything that came out of the computer also was illegally obtained. Thus, fruit of the poisonous tree. The good faith exception. If an officer conducted a search relying on a warrant that he or she believed in good faith to be a good warrant, the illegally obtained evidence can still be admissible based on a good faith exception. And I strongly encourage you to read page 467 in your textbook, where examples of the good faith exception do not apply. So, Chapter 16, let's breeze into here. We'll talk a little bit about arrest and investigatory detention. So, arrest, the warrant requirement. Again, review. The arrest warrant is routine in cases where an arrest is to be made based on an indictment by a grand jury. Let's say that there is a suspicion that Joe Smith has killed his wife. A prosecutor files a document known as an information, and it goes to the grand jury because it's a felony level offense, violent offense. The court then says, yes, Miss Prosecutor, you have enough evidence to, excuse me, arrest this person and charge them with first degree murder. The court issues a document directing the arrest of that defendant. Now, this will generally happen when a suspect doesn't even know he or she is under investigation. So once a grand jury says, yes, there's enough evidence to arrest and charge that person with whatever felony crime it is, you still need to get the arrest warrant before you can take that person into custody. Warrantless arrests now. An officer make a warrantless arrest if they observe someone committing a felony or had probable cause to believe that a person had committed or was committing a felony. But what about misdemeanors? Your textbook really doesn't do a very good job of explaining this. Per the textbook, an officer can only make a warrantless arrest if they observe someone in the commission of the misdemeanor act. So I pose this question to you. Folks, what about domestic violence, domestic assault? Most states, for the first offense, domestic assault, especially without a weapon, is generally classifies this crime as a misdemeanor offense. However, most states allow officers to arrest the suspect uh, for the domestic assault um, crime without even witnessing this. So, what I'm going to tell you is this, you're getting a gimme here. Number 7 on your quiz. Um, Number 7 on your quiz, you can pick true. If you pick false, you're getting it anyway because your textbook does a terrible, terrible job and it really doesn't give you the appropriate information here. An officer does not have to witness all misdemeanor offenses in order to conduct a warrantless arrest. There are specific exceptions that your textbook fails to explain. All right, so it's a gimme. All right, investigatory detention. What is reasonable suspicion? Well, you all have heard of probable cause. There's also something called reasonable suspicion, and it's a very important principle in both law enforcement and criminal procedure. Reasonable suspicion is not as weighty or stringent as probable cause. Its definition is a police officer's belief based on all relevant circumstances that criminal activity is afoot. So this level of standard was established with the Terry v. Ohio case when an encounter between a police officer and suspects during which time the suspects were temporarily detained and they were subjected to a pat-down search for weapons. The complaint was the officer didn't have probable cause to stop them and to search them for weapons. However, the Supreme Court determined that probable cause was not needed in this case, but a lower level of standard, what they deemed as reasonable suspicion that criminal activity was occurring or was about to occur, and that standard was sufficient for a pat down for weapons. This became known as the Terry stop. Investigatory detention. How long can one be detained? Supreme Court stated that this type of a detention must be brief, and it varies on whatever type of situation you're in. For most traffic stops, 20 minutes is generally a reasonable amount of time for an investigatory detention. Stop and frisk situations, those Terry stops, must be brief but are based on the totality of the circumstances. Now, a Terry stop is a synonym for investigatory detention, and it is justified, and 40 minutes is not really considered an unreasonable amount of time for this type of a detention. Well, we've only got about 30 seconds left here, so I'm just going to tell you this. Read your chapter. This week's discussion assignment is on Miranda v. Arizona. The written assignment is on the exclusionary rule. I've put on there what I am expecting you to do for your written assignment. Remember to get your late work into me. You may get some points, you may not, but let's get it in and hang in there. I know that we're almost to the end of the quarter. All right, everybody, have a good week.